So up next is Sean Wigand, a highly skilled forensic psychologist, child custody evaluator, family therapist, and expert witness. He specializes in the diagnosis of and assessment of parental alienation, as well as other complex forms of child psychologic maltreatment. For the past 9 years, he has worked with Demos Lorenzos on parental alienation cases throughout the United States as a forensic evaluator, consultant, and expert witness, helping courts make the best possible decisions concerning the best interest of the child.
Here we go. Okay, so here we go. The practice of child custody evaluation has not been well defined in the literature, and this has led to a lack of standards to how to accurately evaluate allegations of parental alienation and domestic violence, which frequently co-occur in high-conflict divorce cases. Custody evaluators tend to rely on methodological approaches that exclude the application of the scientific principles for data gathering, data analysis, report writing, and expert testimony. So the common methodology used among many custody evaluators today in high-conflict divorce cases is they'll interview the parents and the children, they'll make some behavioral observations, they'll do some psychological testing, they'll conduct some collateral interviews, review the case materials, and then write a report that contains the following elements: reason for referral, history of the relationships, family interviews, observations, results of psychological tests, collateral interviews, and sometimes they'll include a best interest of the child factorial analysis, and then most often they'll have some recommendations or conclusions at the end. But what's missing? Typically what's missing is some hypothesis generation, an explication of what hypotheses were tested, and then some actual hypothesis testing embedded in their reports. That's missing. And then, of course, a comparative analysis of the data that's been analyzed with the relevant scientific literature. So if a custody evaluator is going to conduct a scientifically informed custody evaluation, they need to use the scientific method. And that means to generate hypotheses, to test those hypotheses during data analysis, and then compare the data analysis to the relevant scientific literature. And of course, report the findings. And so why is this important? Well, it's important because scientific literature provides operational definitions and working models to help us describe and explain parental alienation and domestic violence in the context of a best interest of the child investigation and determination. So one of the best working models we have for parental alienation, which was recently published last year, 2022, is the 5-factor model, which we just listened to, which involves contact resistance, positive prior relationship, absence of parental abuse, neglect, or unfitness, use of parental alienation behaviors by the favored parent. Of course, the child may exhibit some or many or all of the parental alienation symptoms. So another one that I use often, especially in jurisdictions where there's adverse court rulings, appellate court rulings in New York in particular, I use this whenever a child has been exposed to parental alienation strategies that are likely to cause unwarranted feelings of estrangement. And these strategies could include parental overprotection. That's very common. I see that a lot. Excessive parental pressure, hostility towards the targeted parent, scapegoating the targeted parent, and of course, negative attributions of the targeted parent's intentions. And of course, this is in the DSM-5. It's a diagnostic label that you can use when parental alienation is present. And this is an oldie but a goodie. It's a perverse family drama triangle. First came into literature in 1973. Describes a process where one parent forms a coalition with a child against the other parent due to an enmeshment through, of course, breaching the generational boundary between the parent and the child in a covert way. And when it's queried, the coalition's denied. And so that's one model that I use often, and I put up there that, all of us know who work in this space that the two roles alienated parents frequently occupy is not only they become a rescuer for their, quote, victim child, unquote, they also act as a persecutor in a covert way. So I think this is very helpful and a graphic way to illustrate the victim, villain, rescuer triangle that's created, sustained by the alienating parent. Of course, sometimes when the courts adopt the status quo, then it becomes like a immovable object. So the next one I think is important. In my state, we have 12 best interests of the child factors. So when I do custody evaluations, those are always a concern. Two of them in particular are relevant to factors 2 and factors 4 of the 5-factor model. One is the history, love, affection, other important emotional ties between the child and his or parents, and then the willingness and capacity of each parent to foster a close and continuing relationship between the child and the other parent. Of course, that's always critical in parental alienation cases. A recent chapter written by Dr. Lorandos and Dr. Burnett talks about loyalty conflicts, and this comes up over and over and over again. It's a concept that you need to understand if you're going to be helping courts understand this phenomenon. And so in that latest chapter, some children try to resolve their loyalty conflicts in a manner that's clearly maladaptive by aligning with parent A and rejecting parent B. And this mental process is called parental alienation. So there it is, peer-reviewed literature, 2023. So now let's take a look at the models that we have, the working models. One of the best working models in terms of typologies for domestic violence was by Johnson and Leone in 2005. And they described intimate partner terrorism, which has been traditionally called domestic violence, as violence embedded in a general pattern of controlling behaviors, indicating an attempt to exert control over the partner. And they distinguish that with situational couple violence, which they describe as intimate partner violence absent a relationship-wide pattern of controlling behaviors arising from specific situations that escalate to violence. So anytime you're doing a family evaluation, situational couple violence may be a factor, and it's important for courts to know the difference between those two typologies, because typically we want to paste one, say all domestic violence is intimate partner terrorism, and it's controlling, and it's not. It's just a reality. So in my state, we have a gender-neutral domestic violence statute, which I cite to frequently. So causing or attempting to cause physical or mental harm to a family member by placing a family member in fear of being physically or mentally harmed. And we have a mental injury statute, which when there's parental alienation behaviors present, we can cite to the domestic violence and call it domestic violence because that's how it's codified in statute. And the relevant statute, of course, is 400.11501. And of course, we have family violence, which was recently published in 2018, described as a complex form of aggression that entails a parental figure engaging in long-term use of a variety of aggressive behaviors to harm the relationship between the child and the other parental figure, and or to hurt the other parental figure directly because of their relationship with their child. I thought that's a fantastic definition. I think we should memorize it. I think we should talk about it whenever we're called to testify. So now let's take a look at a de-identified vignette of a case I recently worked on to see how the substantive portion of the custody evaluation process was performed by a court-appointed child custody evaluator in a case that PsychLaw was retained on to provide expert analysis and testimony. So this is the case of A.T. Both parents alleged domestic violence. Mom alleged physical abuse of the children by dad, and dad alleged parental alienation by mom. So A.T., as a 14-year-old, was the oldest of 3 children from the marriage of Mr. and Mrs. T. Mr. and Mrs. T divorced, and Mr. T remarried. A.T. became the center of her parents' conflict following a visitation exchange incident involving A.T.'s younger brother, L.T. And during the exchange, L.T. refused to get out of the car and visit his dad. And after 45 minutes of arguing and cajoling with A.T., Dad picked up A.T. He's a big guy, 6'2", pulled him out of the car, Mom's car, but Mom tried to block Dad, and when that didn't work, she hit him in the face. So they called the police, and everyone was interviewed. Now, A.T. told the police that her mom hit her dad. And after the incident, Dad filed a petition for a protection order against Mom with a request to have her prosecuted for domestic assault. Mom was charged in that same month with the domestic assault, and in response to the acrimony between her parents, A.T. said she wanted to kill herself and was hospitalized for suicidal ideation. The hospital found A.T. was not at risk for committing suicide because she didn't have a plan or an intent, and the most likely cause of her suicidal ideation was parental conflict, loyalty conflict. So following AT's release from the hospital, she began to report that she was afraid of her dad, suddenly. Not afraid of him before, and refused to visit his house, but maintained telephonic and FaceTime contact. And when we had a chance to review audio recordings and, of course, videos of those interactions, which was very illuminating. As mom's domestic assault criminal case began to heat up, she arranged for AT to be interviewed by a social worker at mom's attorney's office for the purpose of having AT change her story about mom hitting dad in the face. The social worker interviewed AT and declared in a report to the court in a declaration sworn that AT was now 100% sure mom never hit dad, and dad made her nervous and scared. That's why she lied to the police. So after receiving the social worker's declaration, the prosecutor, of course, dismissed the assault charges. Yay, AT. All right. AT continued. Let's see. Parenting plan evaluation was ordered by the court to be conducted by the children's lawyer, guardian ad litem, in concert with a psychologist who psychologically tested the parents. And in the report, she said, that it was a female evaluator, GAL, domestic violence, this was the focus of the evaluation, was 4 things: domestic violence of both parties, mental health issues of the children, emotional or physical abuse of the children by either party, and abusive conflict by either party. So here's her methodology broken down in her report when we had to analyze it and talk about it in our report. So interviewed family members, observed mom with all 3 children, observed dad and stepmom with just the youngest child, GT, who at this point wasn't refusing contact, because AT and LT were both refusing contact with dad. And then she conducted collateral interviews, summarized psychological testing results of the parents, wrote some conclusions and recommendations. But guess what? No hypothesis generation or testing. So here's her findings. Mom's a victim of domestic violence. Mom's not a perpetrator. AT and LT are, this is important, quote, are now quite enmeshed with their mother, and both have issues with separating from her and going to school. That appears to not be historically true, factor 2, as their behaviors have become more pronounced in the past couple of years. So, and then in AT and LT's reports of being scared of dad are justified, this is her findings, because they said he was mean, without any real specifics as to him doing anything that would constitute physical abuse or physical neglect, emotional abuse or emotional neglect on his part, other than the conflict that was going on and the loyalty conflict that ensued. The mental health issues of the child, both AT and LT were both expressing suicidal thoughts after this incident and scared of dad after the visitation incident. So here's her recommendations. No contact for dad unless AT and LT want to or initiate contact. Sound familiar? Restraining order against dad to prevent him from being within 500 feet of AT and LT at their school. Prohibition against dad attending any of their school and extracurricular activities. Dad has to go to domestic violence class. Mom, of course, has sole primary custody of all 3 children. So here's what we did. When we were asked to evaluate this case, we took the whole universe of materials that are available to us. Now we're going to look at what my team and I approached this case, how we approached it when we were hired as experts. And after gathering any and all available case materials, we generated several hypotheses, not all of them, we don't have time to go over all of them, and tested them and compared each to the scientific literature. So I'm going to break some of this down and unpack it for you, just to give you a glimpse of the process of what we think should be in custody evaluations. Did AT lie to the police about her mom hitting her dad? That was the first question we're asking. Second question was, did AT lie to the social worker when she reported that she lied to the police because she was afraid of her dad? So the results of our data analysis, combing through this back and forwards, and testing these hypotheses, we looked at the communication, audiovisual, and therapy records, and they all showed that the latter was more likely true than not. So it's a probability statement. Then we compared, and when we compare this to the scientific literature, we asked the question, why do alienated children lie on behalf of the favored parent? And one of the best line of researches we found follows, I'm just going to give you one snippet. Hildreth and Anderson in 2018 found that groups often demand loyalty, and loyalty can corrupt individuals to engage in deceit. Most people view other people's lies as unethical. However, when evaluating their own behavior, people who lie to benefit their group in conditions of loyalty judge their deceit as ethical. So that's what the kids are experiencing. Back to the loyalty conflicts that Dr. Burnett wrote about. So it's important. The next question we asked was, did Mrs. T engage in acts of family violence against Mr. T? And of course, did Mr. T engage in acts of domestic violence against Mrs. T? So after reviewing the records, it showed that the former was more likely true than not, and there was no evidence outside of statements from Mrs. T that were not corroborated that Mr. T ever engaged in domestic violence. And usually when we're going through this data analysis and testing the hypothesis, we're looking for corroborative evidence that shows, anything that we can find. And sometimes we can't answer those questions with any degree of probability of it preponderating this direction or that direction. And we say so. So when we compare this to scientific literature, do alienating parents, this is the question we asked, do alienating parents commit acts of domestic violence and then make false allegations of domestic violence against targeted parents? And if so, why? So we just heard about this study the other day. Sharples, Harmon, and Lorandos, 2023, found that alienating parents are more likely to use other forms of abuse, such as domestic violence and child physical abuse, than targeted parents. And of course, Leona Kopetsky and her team in Verhar in 2022, alienating parents frequently rely on the use of primitive psychological defenses, such as denial, deception, splitting, devaluation, and protective identification, against psychological pain that results in externalizing blame, and what Claywar and Rivlin called other blamers. It's not my fault. She did it. He did it. So the next question we wanted to look at and try to find an answer for was, did AT and LT actually display fear of their father and separation anxiety as described by the LGAL in a report? And the results of our analysis showed that both AT and LT exhibited fear of their father, but not in the presence of their father. And we had lots of data to show us that that wasn't occurring. Kids are fine, they're not scared. And the other relevant data that we saw is we're watching them talk to dad, and they're happy as can be, not afraid. We're running out of time. Okay. So anyway, in the presence of their father, scientific literature, this is important, dysregulated fear. So why do alienated children sometimes display fear for the targeted parent in the presence of the favored parent? Dysregulated fear. There's a whole line of research. I encourage you to look it up. This refers to inordinate levels of distress and low-level threat situations. This is part of the corrupting emotional abuse that happens to alienated children. And they revert to an induced separation anxiety. And you see it across the spectrum. And that's why you see kids who are 14 lose object constancy and go back to these primitive defenses. So that's very helpful research. If you want me, I can give you copies of that. I have it all in my. So was there any support in the data found for the presence of parental alienation of the 5-factor model? And when this was one of the last questions we had to ask. Yes, both AT, LT refused contact. We know that. LGL identified prior positive relationship. We had about 15 other pieces of evidence, family photos, family videos, yada, yada, yada. Factor 3, there was no evidence of seriously flawed parenting, abuse, or neglect by the targeted parent. And we did find exposure to alienating behaviors, limiting contact, and bad mouthing were the top two. And of course, symptoms that we found was there was an evidence, and I didn't get a chance to put it in this limited vignette, but there was evidence of campaign of denigration, frivolous rationalizations, borrowed scenarios, reflexive support for the favored parent. That's just about all that we found. But it's enough to say, and that's why this model is so helpful, to give us a wraparound, if you will, of what's going on with these kids. So this is just an overview of what happens when you apply the scientific methodology to child custody. This is what it should look like. You're generating hypotheses in the data gathering part of your investigation into a best interest. And then when you test the data, you test your hypotheses, and of course you integrate them in your findings. So any questions and answers?
We'll bring the microphone to you.
Will these be, are you sharing these slides with us?
Sure, if you want. Huh? I can send it.
So my question is, here in Colorado, we have both child and family investigators and parental responsibility evaluators. And in the orders, the parties or council are supposed to identify the specific issues that the PRE or CFI is supposed to address. And so commonly what I see is just listing of all the best interest factors, which to me is not a specific issue. And I'm an attorney and I'm no longer a CFI, but I was a CFI. And so when I do orders, I try to put in, the specific issues. And if I had a PA case, I would list the 5 factors as the specific issues, evidence of this, evidence of that, blah, blah, blah. But so are you suggesting then that then maybe in the orders, proposing the hypothetical questions, or is that something that should be left up to the evaluator or the PRE or the CFI to devise? Because they, and I'm kind of maybe answering my own question, they can't go beyond what's in their orders.
I think the more that you circumscribe what needs to be explored, the better. The more explicit you get in your orders, the easier it'll be for the evaluator to know what their marching orders are, especially if you have a lazy evaluator who's just, punching the clock.
Mr. Wygant, you had a room full of people photographing your slides. May I say www.psychlaw.net.
It's right there. That's my last slide. There you go. Shameless plug, huh? Okay. Any other questions? Okay. Thank you very much.